uh, by Benjamin Franklin right after the Constitutional Convention finished writing the Constitution. And a reporter or someone came up to him and said, Dr. Franklin, what have you given us? And he didn't answer like, oh, it's a constitution or anything like that. He said something really profound. A republic, and then paused, if you can keep it. And that is why the Constitution is known as the grand experiment. A constitution that had that level of specificity as far as a government structure and process and so forth had never really been tried before. Even going back to the ancient Greeks with the various constitutions they had at different times in Athens, for example, or even the English Constitution, which is unwritten, uh, didn't have that kind of specificity. And so a question becomes rather obvious. How do you figure out what the words mean? And that's what our concern is today. Even today, 238 years later, that question is still asked. And so there are lots of different resources. Uh, I've got a list of my favorite ones on differing sides of the political and philosophical aisles. Robert Bork, who was a Court of Appeals judge and was denied a seat on the Supreme Court, wrote a book called The Tempting of America, where he laid out his view of what's called originalism, where he felt that the only really valid way to interpret the Constitution in an objective way was to look at the original intent and meaning of that document. Antonin Scalia, who went on to the Supreme Court and was there for 28 years, uh, published two books that are of relevance here. The first was A Matter of Interpretation. Um, and that was a series, a collection of a couple of talks and that he did, and he laid out his idea of what's called um, textual originalism, where he says what it's not original intent of like the framers or whatever, although that's important. The real tell is the original meaning of the words of the text as they would have been understood by the 18th century individuals reading it, or getting as close to that as you can. In his chambers, he had the oldest reputable full length dictionary, English dictionary, that he could find. It was a large one, thick. And it was from 1824. And if there was ever a question where something seemed like a more modern definition or whatever, he'd always tell the clerk, go over there, look it up, and see if it fits. Another book that he wrote with a co author was Reading Law, the interpretation of legal text. And what he did with that was he labeled out a series of what are called canons of interpretation or rules that you use to interpret legal texts, whether it's a statute or a constitution or regulations. It didn't matter. Those canons followed you. Then a colleague of Justice Breyer, uh, no, of Justice Scalia, was Justice Stephen Breyer. And he wrote four specific books, but two are relevant to us. Making Democracy Work, a Judge's View. And in that, he was talking about the idea that one of the roles of a judge in interpreting the Constitution is to do it in such a way that the democratic ideal, the democratic function of the Constitution is workable, not to any particular side, but just is it workable? Like, say, for example, you have two opposing elements of the Constitution that seem to work against one another. And he says when you're interpreting it, you should be interpreted in a way that it actually works rather than creates problems of its own later on down the road. And in that way, a judge is living up to their oath um, of doing justice and doing right without regard to the rich or poor and all of this. But he laid this out, and then when he retired in 2022, he wrote a book called "Reading the Constitution: Why I Chose Pragmatism, Not Textualism." And it basically boiled down for him on that workability and the fact that language also changes over time. And if we get to a point where the language is simply not understandable by the everyday people of our country, since it's our Constitution, then the rights and liberties that are protected decrease over time, whether it's speech, whether it is freedom of the press, whether it is what's protected by the Fourth Amendment, and so forth. And he lays out a fairly solid case for that. Now, not everybody agrees or disagrees with all of these things, and that's fine. But at least we have material from actual judges at those levels that is giving us an idea of how difficult the process really is. And we're better able to understand just what it is the judges are doing up there. So if we find a decision that we utterly disagree with, uh, we can look at it and say, okay, now just what were they thinking about when they did this? How were they interpreting the words? Why were they interpreting the words that way? And it's really important that we start to look at how they're doing their job rather than a conclusion that a court reaches on a particular issue. For example, when the court deals with a controversial issue, such as flag burning or abortion, prayer in school, or any of a host of controversial but legitimate constitutional questions, at the end of the day, they are not looking at whether something is good or bad. Is this a good policy or a bad policy? Is this a good idea or a bad idea? What they are really looking at is there authority to actually do this? And so most people, not through uh, malicious intent at all, but most people are very much mistaken about what the courts are actually saying. Okay. For example, in the Roe v. Wade case in 1972, William Brennan was a very staunch, devout Catholic. He hated abortion with a passion. But in his research, in his heart of hearts, when it came to what the Constitution requires, based upon the issues of privacy, medical necessity issues, and a host of other things that fall into line, he said, I don't have a choice. The government does not have the full authority to ban abortion at any stage of a pregnancy. Uh, and the compromise that was worked out basically supported that view. And he basically went to confession the very day that it was issued. But he said, I can't, in all good conscience, violate my oath of office to put forth the law as I find it. It's not my role to say whether something's good or bad. Antonin Scalia would say to his law clerks all the time, the term that I find no problem with any decision that I make as far as my personal views is the day I retire. because I'm not doing my job. I have to be able to write an opinion if it's warranted that goes against my personal political views, moral views, or whatever, because my oath of office is to the law, not to a particular point of view. And judges, by and large, do that. I mean, and that's why most judges that I've ever studied, even the ones I seriously disagree with on the law, I can have a very high regard for and respect because I look at how they are going about interpreting and the process they go through to get to the conclusion they reach. I can disagree with the conclusions, and I do a lot of times, but I would say about 98% of the time I can respect the reasoning behind a conclusion that I disagree with. There's about 2% of the time where I'm like, I can't. It's so far out in left field that I'm just not seeing the connector points, the A to B to C to D type of thing. Um, and uh, I feel that that's a pretty good assessment uh, of of judges. Um, the
1850.
the the work is very difficult, and at the end of the day, um, the judges have to be able to issue the hard decisions, especially the ones they know are going to be unpopular. Okay, and I think that's why I have such a high regard for judges, even the ones I disagree with, because they know they're going to be unpopular, and um, the the time they put into it, the study they put into it, all you have to do is listen to an oral argument, and you come away realize, wow, these people are very, very prepared, and it doesn't matter who they are for. Does that mean that areas of law have suffered at different times for different reasons? Yes. Marie, I can honestly say that for most of our history, the courts have not done a good job of looking at Native Americans in terms of the legal side of things. Uh, and we're finally starting to see a shift. It's not massive, but the McGirt decision in Oklahoma just a few years ago is kind of it was kind of a breath of fresh air a little bit, but it's not nearly enough. And so, again, I understand where people can look at it and say, "Wow, it's a work in progress." And that's the next point I wanted to make before we get into an issue or a segment of the Constitution. In 1987, on the 200th anniversary of the signing of the Constitution and sending it to the states to be ratified, Justice Thurgood Marshall, went to Hawaii by invitation to give a speech celebrating the 200th anniversary. And he took the time to talk about the fact that for all of the good things in that document, and he recognized there's some phenomenal things, it was an imperfect document, and that it was in fact a work in progress. Otherwise, we would not need an amendment process. We would not have needed a Bill of Rights. We would not have fought a civil war over a significant social issue that had constitutional imprimatur. And so we get to live in a dynamic country whose fundamental structure of law is in an ongoing process.
Greg, can I interrupt you for just a second?
Sure.
It's a little bit hard to hear. Can those of us who are on, can we mute so that our background noise isn't interfering?
Yeah.
Okay, thanks.
Yeah, and then just turn on your microphones when you have a question, and that's perfectly fine. Okay. And so I'm always excited to look at this subject because there's no final answer. Regardless of the judicial philosophy or interpretive philosophy a person holds, it's always going to be, there's always going to be questions, and they're always going to be dynamic. And so let's go and start talking about an issue. And a lot of the issues that impact us on a day-to-day basis come out of the Bill of Rights. It's just the nature of it. I would love it if we could focus more on the original section of the Constitution. The Bill of Rights provides us something really unique, where the interpretive philosophies really come into play. And so first I wanted to look at the First Amendment. And the First Amendment was originally in what was sent to the states, the Third Amendment. But the first two amendments were not ratified. So by default, what we know as the First Amendment became the First Amendment. And it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, in that short amendment, there are a lot of moving pieces. The first thing that should be noticed is the categorical statement, Congress shall make no law. Now, that's an interesting phrase. It seems very absolute. Yet, with the exception of two justices in all 235 years of the Supreme Court, with the exception of two justices, everybody has said there are exceptions, but they have to be very narrow and they have to uphold a significantly legitimate government purpose. The two-pronged test. The two that felt that no law really did mean absolutely no law whatsoever were Hugo Black, who served from 1937 to 1971, and William O. Douglas, who served from 1939 to 1975. And they were of the opinion that words matter. You say no, that means no. And the framers were not stupid. They knew what they were saying when they said Congress shall make no law. How difficult is it to understand that basic idea? That was their point of view. And so because of that, they said no, judges cannot um, punish contempt of court. You cannot sue for defamation. You cannot sue for slander, and a host of other things, all because of that little tiny phrase. And so, right there, we see just how important having a judicial philosophy to interpret these words really is. But let's go on just slightly more. Most people say freedom of religion when they mention the First Amendment. It doesn't say that. Freedom of religion encompasses the whole thing. Our Constitution separates it into two pieces, establishment of religion and then free exercise. Now, most people taking that first part will argue, and with some credibility, will argue that it means, oh, no state religion. Like a state, the federal government can't say this is going to be a Methodist nation. We're going to support the Methodist Church, and so forth. Okay. However, looking at it from what's called a purely textualist point of view, for that to be accurate, unless you basically eschew the textualist point of view for that issue, it's missing one word. Look at what it says: the establishment of religion. That's the general term of religion. That generally signifies any religion whatsoever. So you can't establishment or do something that essentially establishes the format of religion in general. If it said the an establishment of a religion, the singular, that would support the idea of a state church. Now, I'm not going to say that one is right over the other. Okay, it's still debated to this day. The courts still debate it to a certain extent. And as a result, we have cases involving significant issues such as prayer in school, funding for religious activities by government entities, uh, the posting of religious texts in schools or courthouses or religious monuments on publicly funded grounds, things like that, all over the place. The question becomes, what does the First Amendment mean with respect to establishment of religion? An area that impacts us on a daily basis, and we can see it in our own lives. Next part, prohibiting the free exercise thereof. The big question becomes, what does the phrase free exercise mean? And how do you get to a conclusion on that? Free exercise can mean different things for a lot of different people. And yet judges have to come up with an interpretation that can meet the needs of a large, very pluralistic country when it comes to religion, so that the negative impacts of such a decision are minimized to the highest degree possible. And we see that with respect to those that are of different religious faiths entirely, because we see communities that have large Hindi populations, Muslim populations, Jewish populations. We've even seen some growth in uh, Shinto with large Japanese communities, for example. Um, it becomes a real question mark that wasn't necessarily there in 1787, but it does exist now. And the words were broadly written in order to foresee possible changes in what we see right before us. And so the words are designed to be lasting for centuries. The question becomes, how do we interpret those so that it is a workable frame to let it last those centuries? Then here's my next one, my favorite one to work with: freedom of speech. Okay. The big question is, what is speech? Okay. Now, if you look from a purely original perspective of what they probably had in mind at that time, they were looking at political speech. At that time, political pamphlets were very popular on all sorts of different subjects to try and reach the masses. Uh, and it was not uncommon to have political speakers in the public square all the time. That was a big part of entertainment. And in a country that focused on regular elections and local governments, broader state governments, federal government, the idea that you don't protect the ability of people to speak on political subjects didn't make sense to them. And so they put that in there, and that was like their intent. But look at what we protect as speech now. And I'm going by court opinions that we on what we've protected. The spending of money in political campaigns to facilitate speech, but the act of contributing money is considered speech itself, has been since the opinion Buckley v. Vallejo in 1976. Another thing that impacts us to this day. Expressive speech in terms of, say, pantomime, for example, and you have a vulgar display, but it's not necessarily in public. Question becomes, can you prosecute it? Or if you have a law that forbids it, is it a law that violates freedom of speech because it's expressive conduct, which is an element of speech, especially if it wasn't in public? It was more, say, a private party, and you have a vulgar pantomime show. Just as a hypothetical, the court has to be able to answer that. And the courts have, on similar questions, have gone back and forth with it. But it's not such an easy question when you start adding things to terms like speech. What does it encompass? In addition, what does freedom mean? Freedom of speech. Does it mean you can do anything? Does it mean that it has boundaries? Or is it somewhere in between? Those are all questions that judges will ask. And then they're going to ask a lawyer, by the way, say we agree with you and we give you what you want, just for fun and giggles. How is it going to impact other areas of law where that interpretation or that analysis has to be done the same way for this other area of law? Particularly if you go into the 14th Amendment, for example. And that's the real crux. When judges make an interpretation of law in one area and the analysis is relevant to other areas of law as well, they're going to ask the lawyers, say, hey, we understand what you're saying. We may agree with what you're saying on this particular issue, but that's not the end of the debate. What's it going to mean for this area over here? Unintended consequences, for example. And as a result, it becomes even more complicated. But courts, and I'll leave out press and assembly and petition for now, but courts, I think, and here's my opinion on this, have by and large done a pretty good job. Does it give us everything we want all the time? No. Does it give relevancy to the idea that there are rights that are protected and that courts are serious about protecting rights, but also recognizing that rights are not absolute in their nature? Yes, they have. And there are going to be times where we do seriously disagree with courts. But the important thing is to ask yourself, all of us should, why are we disagreeing with them? Is it simply we disagree with the conclusion and nothing else? In which case, that's troubling. Or is it, do we have serious disagreement with the analysis of why they reached that or how they reached that conclusion? If you disagree with that, that is a good thing. It's a healthy thing. Because while judges will make mistakes, sorry, the fire alarm went off. My parents are cooking. Give it a moment, it'll stop. There, okay. And but if we can get to a point where we can have seriously good, vibrant disagreements about how you get to those conclusions, how you went about interpreting the Constitution.
Greg, can I ask you a question?
Sure.
How, if we have disagreed with something that has been from the Supreme Court, how are we able to know how they came to that conclusion? Is it a written conclusion when they
Yes.
finish so that it can be
Yes.
read? Okay. Okay, that's
Every
why.
decision on the merits that this court makes, a written opinion is issued. And if there are any dissents, they're issued at the same time. And if there are any what are called concurrences, they are issued at the same time. The concurrences are where a judge will say, I agree with the conclusion, but I disagree with some of the analysis, and here's why. And here's how I would approach it a little bit differently. And there's a website for the court opinions. They're also in bound volumes. They've reached volume 605, I think, right by now. Um, oh, that's nothing compared to the courts of appeals. The U.S. Court of Appeals from 1924 to now, 999 volumes of the Federal Second Reporter, 999 volumes of the Federal Third Reporter, and roughly 400 volumes of the Federal Fourth Reporter. I mean, lots of opinions. The Supreme Court will average any right now. The Supreme Court averages about 60 to 75 decisions a year, or cases decided a year. And there's good things and bad things about that. Roughly 8,000 cases reach the court each year asking the court to take their case. The court has the the authority to decide which cases they will take. And they have basic rules for choosing a case. Is there a split among the lower courts on the same case or on the same issue? Is it an area of law that's brand new and they've never done anything with? Is there an area of law where the lower courts are faithfully in accord, but they're pointing out that they don't have much of a choice, but there's some real problems here, like problems understanding how to really implement the Supreme Court's opinions, or really having a problem implementing carefully a particular statute, or just a number of different things like that, where they're going to be like, okay, we'll take this case and give some better guidance for the lower courts. And but they about 8 to 9,000 a year are petition the court. The court will take about 60 to 75, like I said, for decision on what's called on the merits. They will also decide usually about 25 or 30 opinions on what's called an emergency docket, where they basically say, okay, here's what we want you to do. Like it's an emergency appeal from an injunction or a denial of an injunction, for example, and they will decide it on an emergency docket, usually with just a short little memo. But they're not deciding any major area of law with it, or they're not supposed to. And but the court, there's the good thing about what the court does as far as having so little of the cases. One, the vast majority of the cases that are petitioned to the court, they're not important cases. They're not big cases, and really, they're the types of no-brainer stuff that likely should never have gotten to the appellate court, let alone brought in a major way at a district court. But they were, and they have a right to. But once you've had a district court on the merits, you've had an appellate court review it. The view is, and it's been that way since 1925, Supreme Court, they're not there to correct errors. They're there to provide a uniform interpretation in an area of law so that the lower courts can deal with people properly. And so The good thing is the court is able to take the time to write out and seriously consider the issues on all sides. And so the finished work product is much better. When the court was taking and deciding about 150 to 200 cases a year, the work product was not nearly as thorough, not nearly as good, at least in my opinion. And as a result, you had much more confusion in the lower courts about what the Supreme Court had done. If I was to pick a number that I thought would be appropriate for the court to handle each year, I would say about 100 out of that 8 to 9,000.
Greg,
Yes.
who then makes the decisions as to which cases they feel are worthwhile for them to handle?
Okay, the court as a conference decides. All 9 members of the court decide it. And there's one principal rule unless it is for a rehearing of a case. And that is what's called the rule of 4. If 4 out of the 9 justices think it's a case that should be seriously looked at, briefed, and argued, the court takes the case. Sometimes only 3 want the case, but they're so passionate about it, someone will switch their view so that they can have it. I mean, they're very good about that when it comes down to it. But basically, the rule of 4, and it makes sense really, because it shouldn't take a majority to simply bring a case from a lower court, but it should be enough of them that they can take the case seriously. It's like, because the rest probably thought this is a no-brainer. Why are we even bothering with this when we have really important cases over here we can spend our time on? Okay. The It's not set by statute how that's done. The court, like Congress, has the constitutional authority to develop its own rules, internal working rules. Okay. The internal working rules have been worked out and structured over time. Okay. Every generation, there's a little bit of alteration in the internal working, sometimes based on technology, sometimes based on the growth of the workload of the court, sometimes because of something like COVID, where they heard arguments remotely, where they heard it by phone in their offices instead of in the courtroom. And as a result, you make alterations in your internal processes. And when you look at the different changes over the last 200 years, you can identify pretty much in a linear pattern the benefits of those changes. It's been really remarkable. I have yet to see a change in the internal processes of the court in 200 years that, quite frankly, would be concerning in terms of what they're. In 1849, for example, they set time limits on the lawyers arguing the cases to 2 hours per lawyer. Before it was however long you want, because they didn't have written briefs until the mid 1830s. And so the oral argument actually not only made the argument the law, it also presented the actual case to them, said, here's what happened, da 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 da, for hours on end. And so you had incredible orators like Daniel Webster and John Calhoun and Henry Clay before the Supreme Court. But at all times through this history, the court has struggled, and the justices have struggled, and lower court judges have struggled with just what tools do we use to interpret these words. For me personally, I have an awful lot of respect for all of the tools that they use. And if they choose to use less, I have respect for that, because the reasoning behind them choosing less tools is because they want to be as objective as possible and not let their personal points of view seep in. Um, I don't necessarily agree with the rationale, but I respect it quite a bit because they're trying to do the best job that they can and narrow the possibility of giving in to temptation, so to speak.
Hold on.
It is
What word?
also pretty evident in looking at how complex some of these issues can be that having a trained professional judiciary, as far as trained attorneys and so forth, being the judges or being appointed judges, is really important. Uh, I cannot think of anybody, even some of the most incredible scholars I can think of, that are not lawyers who would be able to really do the job as a judge on an appellate court, and especially not on a trial. And it's because the work you have to do is so um, integrated into a host of different concerns. And you have to be trained to be able to look at words and differentiate between what are called terms of art or common language. You have to be able to look at history in a very focused way. You have to be able to determine when history is relevant and when it isn't. And when you have conflicting um, and pieces of history from the same time period, which one do you use? And as a result, it's an incredibly labor intensive job. But the Constitution itself is something that we should be very much in awe of in terms of one, how long it's lasted, two, how difficult it is to work with it, but also kind of feel good that we're not finished yet. And there are areas of law that I think the court has just been profoundly um, out of out of out of bounds with respect to uh, what the initial promises of the document were and what they did with it at times. Um, I mentioned earlier about Native Americans. When I look at the 14th Amendment and what the court did with it in 1883, with the initial civil rights cases from 1883, I'm just like, and then just a few years later, after saying that the 14th Amendment really wasn't going to protect um, the civil rights of African Americans at that time, they turn around just a few years later and say, oh, by the way, corporations are people under the Constitution, and therefore their rights as people are protected. And that's why corporations have free speech rights and all that comes with it, such as the spending of money by corporations in elections. Okay, I'm not making value judgments on that. I'm just saying these are the things of that history where we say, you know, we may have been able to do better. The court may very well be right about corporations or been right about corporations. But what about what the 14th Amendment was originally there for? In terms of Native Americans, what about the protection as sovereign entities that Native American tribes were supposed to be? And the courts failed that in a lot of ways, uh, especially through the 19th century and even more into the 20th century. So I think as we look at the Constitution and we look at issues and so forth, we can at least approach it with uh, what Thurgood Marshall said. It's a work in progress. And we can further look at it and say courts aren't always going to get it right, but we can at least understand how they go about doing the interpretive work that they do so that we can better understand what it is they give us. And hopefully, Benjamin Franklin's statement, a republic, if you can keep it, maybe we can show that we can keep it, because it basically means that everything's firing on all cylinders, whether the executive, the legislative, or the judicial branch, they all need to be working fluidly. And a lot of people are concerned nowadays for different reasons, different perspectives. But my encouragement is, let's learn a little bit more. Maybe right, but let's keep learning and keep focusing. Next week, I want to look at some other pieces than just the First Amendment. I want to look at some other parts of the Constitution that we can see playing out in our everyday lives. I think it's important to recognize that the document does indeed have an impact on us, not just, oh, that what's going on over there or over there, over there, but what about me type of thing. It's like, well, it does, because a lot of the ways in which we go about our daily lives, it's informed because we know where the boundaries are, or at least we have a chance to know where the boundaries are. And if we feel we've been wronged, we know what we can argue, at least credibly argue. And so next week we'll continue with that. I thank everybody for your attention and for the questions I got. Is there any questions or anything before we end this evening?
Question? Yeah, I have one, and
Uh-huh.
it's to the Rick, by the way. What's going on right now? How the lower court judges are making decisions. I don't know how to put this, but it's when they send the folks back to wherever country they come from, and
Okay.
the lesser judges are able to.
All
Um,
right. A couple of factors are at play. Okay. And this is without saying whether I agree or disagree with one court or another. First, almost every single decision that's been handed back to them has been done on what's called an emergency docket, which means that those decisions by the Supreme Court are what's called non-precedential. You basically, on the merits of the legal arguments, the lower courts can't are not bound by those decisions as far as the legal rationale. If somebody comes and says, here's a change in circumstance, or here is a change in process, it opens up an entirely different question.
mhm.
And therefore, the what's called the emergency docket or shadow docket order is no longer applicable. And therefore, they are able to do that. Does it mean that they won't be overturned? No. But it isn't a situation of simply thumbing their nose at the court. There's a reason they've been able to do that. Now, the Supreme Court may take one of those cases on the merits and very quickly decide it and say, this is no longer going to be done. But it has to be on what's called a merits decision. It can't be on a shadow docket decision. And that's the principal reason behind
Greg, when the president uses his executive order that we see him using quite a lot, is that totally legal for him to do that in any case that he wants to?
that. No.
Okay.
And here's where myself and a lot of other legal scholars are having some real troubles with what the Supreme Court has been doing. Okay. Historically, and by court precedent, executive orders have to follow a couple of basic rules. First, it cannot make new law. And second, it can only give clarification or guidance to existing law. And so, what we see here in most of the instances goes well beyond existing law when you have federal action taken in relation to it, that you have statutes, for example, that directly say the opposite. And as a result, a lot of legal scholars are really scratching their heads and saying, look, we're not arguing about whether it's a good policy or not. This just is not the way it's always been understood as far as how executive orders work.
Well,
In
that's what I
addition,
think. I think
yeah,
those of us are getting frustrated when we see him doing this, and we're wondering, why doesn't the court do anything about this? Why isn't somebody saying, no, you cannot do this?
yeah,
At least
okay.
I get frustrated.
Without casting aspersions on any organization or group or individuals, since about 1975, when uh, conservative legal um, organizations like the Federalist Society, for example, started to develop, and they started to put forward views about the Constitution, about how to interpret the Constitution, and so forth. Most of those views have been considered quite against what has been generally understood to be authoritative in that field. And one of the biggies has been about executive authority and using a theory called the unitary executive. Now, the unitary executive exists because the Constitution only mentions one executive officer, and that's the president. Everything else is created by act of Congress.
Mm-hmm.
But the problem with the way these groups are looking at the unitary executive is because of that, the president can essentially do whatever they want within the gamut of executive of Article 2 authority under the Constitution. Most scholars, even most moderate conservative scholars, will say, no, that's not right. Do they have extensive authority? Yes. But, like, for example, in terms of federal officers uh, in the civil service, for example, and when you have cabinet officers or sub cabinet officers, or you have regulatory agencies and so forth, those are all created by Congress. And it makes sense if they don't have standards in place as far as when the president can fire an individual. We're not talking about cabinet officials. We're talking about civil servants, professional civil servants. We're talking about heads of regulatory agencies that are on multi-member boards, for example, stuff like that. It's supposed to be Congress created it, therefore Congress can destroy it if they want. But the president has to kind of follow the rules too. If they were right about the unitary executive, remember the Iran Contra scandal? And remember the ban on aiding the Contras?
Mm-hmm.
And it was called the Boland Amendment. It was an act, it was part of the spending package and the budget agreement around 1982 or 83. And it said that no monies could be spent supporting the Contra effort to overthrow the Sandinista government in Nicaragua. And if if the Federal Society and others are correct about the unitary executive, a president can say, well, I think that's BS. I don't have to do that because I'm the unitary executive. So I'm going to do what I want when it comes to foreign policy, no matter what. I think you run into some serious problems with that.
Mm-hmm.
And so as a result, I've historically been very much against an expansive reading of the unitary executive. I think there's certain aspects of it that are certainly in existence and real. But I also think what we've been seeing, um, I think under George W. Bush, to a certain extent, his view of the unitary executive was beyond the boundaries. I think most certainly under Trump, it's without looking at whether I agree or disagree with the policy, even. It's how do you get from an idea to it being real? And you have to follow the proper processes because really, at the end of the day, what protects our liberties and our rights? The processes. And if we have somebody that sweeps away the processes and goes beyond the legitimate bounds, then our rights are not going to be protected. I'll be honest with you, I genuinely think Antonin Scalia, if he were still alive and on the court, would in all likelihood have voted no on a number of these executive orders. Say no, it's beyond the boundaries. The unitary executive is real, but not that real. And that's just what I feel about it, and how this is coming about. But I think if we were ever to have a time where we would have constitutional amendments in the future about Article 2 of the Constitution, clarifying it, hemming it in, or whatever, and having a very real chance of it passing, this not just Congress, but also the states, it'll be within the next 15 years.
Greg, you're incredible. You can keep, you can keep all this up here and you can pull it out when you need it. And I so appreciate you doing this for us because some of us have never really taken the time to study it, nor have we had an interest in it. And I think it's something we need to do. Yeah. So I appreciate tonight. I'm looking forward to next week.
Okay, thank you. My view is my role, put information out there. Whether people agree with me on my conclusions or ideas or not is totally fine. Because the more information people have, the more they can actually go out there and make informed decisions about whether they like something, dislike something, and also articulate why. Because so many people out there today make a knee-jerk reaction to something, but they can't really articulate why it is they have those ideas. And that's troubling to me. Rick, thank you for that question, by the way. And you too, Carol. They were really good questions.
So, Greg, when
yes.
did executive orders, what president first started that?
We've had executive orders since George Washington. Executive orders can be anything from saying, I'm ordering flags at half-mast on all military bases in honor of such and such. That's usually an executive order. It can be an executive order proclaiming a national day of Thanksgiving. It really started to come into play right around the time of Theodore Roosevelt. And it wasn't in a disastrously expansive way, but he started doing more about what government can do. But he kept it hemmed in pretty carefully. I think the one thing that he did that was probably beyond the pale, we had just made a brand new all metal, all coal-fired naval fleet called the Great White Fleet. And Theodore Roosevelt wanted to send it on a around the world tour to show other countries that we were here and we have a navy to be proud of. Congress wouldn't give him the money. So he told the Navy, okay, send the fleet halfway around the world. Then I'll just tell Congress if they want it back, they have to give me the money. And he did that by an executive order. Executive orders also can develop policy within the executive branch. A really important one was the executive order by President Ford that forbade U.S. intelligence assets from engaging in organizing and carrying out political assassinations. And that took place after the attempted political assassination in Chile.
What was the name of the president in Chile?
Um, oh, geez, what was his name? Let me see.
Tall, thin dude.
Allende. Allende.
Allende.
Yes.
And see, how can we accuse someone of insurrection when the president or whoever makes decisions in spite of the Constitution?
That's why some of the decisions in the last few years have been so troubling by the court. The argument.
I'm not trying to change nothing. I just want to.
Oh no, it's a very valid question. Okay. When Nixon tried to get out of the Watergate issue, he tried to say, I have absolute immunity, executive privilege on everything. The Supreme Court said no. They said executive privilege, it exists. Is there some level of immunity for presidents? Yes. But absolute blanket immunity? No. And when it comes to a criminal case, you're at the bottom of the barrel of your immunity. What the court did for Trump comes in a couple of different levels, and all of it disturbing. Warren Burger in 1974 tried to write an opinion in which he was kind of laudatory for the efforts of Nixon to be cooperative and all that, and said, well, when it comes down to it, if it's a core function, then we can say the president's okay. If not, then we can go after him and all that. The rest of this court said no, it would cause too many problems and you're just asking for trouble in the future. What the court did with Trump was they said if it's a core function of the presidency, he has absolute immunity, cannot look at it at all. If it is a part of the presidency, but it's not a core function, there's what's called presumptive immunity, but it's not absolute. And if it's outside the functions of the presidency or the office of the presidency, no immunity. Or a court can decide that it's tangentially related, and so they can give some immunity. The problem with core functions is very simple. You can do it with an extreme hypothetical, but it could be realistic if you have a president, whoever it is, Democrat, Republican, whatever in the future, that is having a meeting in the Oval Office with a person not of the government, and they are talking about a genuine hit on a political opponent. And during that meeting, the president picks up the phone and calls the attorney general and said, by the way, I just wanted to give you a heads up. I'm in the Oval Office talking to so and so about our issues involving you know who, da 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 da. If anything ever comes up, I just wanted you in the loop. Click. At that very moment, because he contacted and was in discussion over that discussion with a cabinet official, that illegal meeting just became fully immunized because of core function analysis. Because the second he talks to a cabinet official in a meeting, that meeting is a core function. And therefore, if a political hit happens and someone dies, the president is totally immune, even if he planned it.
That sucks. No, wait a minute. That when I was in high school and went to college, we were told we could not sue the president. We had to have special needs to.
Okay.
I never could understand that.
All right. There's something called sovereign immunity. And there's two types of suits. There is a suit against a person in their personal capacity, and a suit against a person in their official capacity. If it's in their official capacity, they can be labeled on the suit, but in reality, it's a suit against the government. in which case a government, unless the Congress by statute has given the courts jurisdiction over a particular subject, clearly giving it, or what's called waiving sovereign immunity, then the government's protected, and the courts will say, "Sorry, we can't hear this case." If it's in his, if he's being sued in his personal capacity, in which the attempt would be on a hypothetical like I gave would be in his personal capacity, the court would have to look as to whether or not the activity at that time was a core function or not.
Oh, that's the key right there, isn't it?
That's right. And that's why what the court did in the Trump case is so troubling. I heard of the result, and I normally do not look at a result before I read a court opinion, but I happened to turn the TV on, not knowing the case was coming down that day, and it blared out, but I was like, what? And then I turned it off immediately and I read the opinions. And I about had a heart attack when I read that opinion. I have rarely, outside of the Dobbs decision, seen a Supreme Court opinion that poorly designed and that poorly reasoned. And that's without saying whether the result was right or wrong. It's just a poorly set out and reasoned opinion to reach the result they did. It will be an opinion, because of how it did it, that will go down, almost assured to go down in history, like Dred Scott, Plessy v. Ferguson, and now this, as what's called a self-inflicted wound, where the court could have done a much better job of granting, say, limited immunity and saying it applies in this case, as opposed to doing what they did. And there's a reason I got upset to start with. We always talk about the framers knowing what they're doing. They knew what they were putting into that document. They debated what they were putting in that document. There's only one piece in that document that discusses immunity when it comes to the Congress, President, or Supreme Court. And that's the speech and debate clause of the first article, and it only applies to members of Congress and the Senate. If they had wanted the president to have a serious level of immunity, they absolutely knew how to do it, and they didn't.
Well, it's 8:30. We'll quit asking questions, Greg.
Okay. It could go on all night, to be perfectly honest.
Greg, thank you.
You're welcome. It's
Yes,
great
thank
to have
you.
you here. Mm-hmm.
Thank you,
And
Greg.
we'll continue next week on Monday. And I missed the opening part about how the appellate courts work as far as recording, but I have this recorded. I'll put it on our Facebook page and go from there. Okay.
Okay, thank you.
Thank you. I enjoyed it very much, everybody.
Everybody have a good night.
Good
You
night.
too.
Night.
Good night.
Saturday?
See you all
Yeah,
Saturday.
Saturday at 3:00 at the Coach House.
Oh, that's right. That's Coach House. Okay.
Yeah.
Thanks, Greg. Good night.
You're welcome.
Night.
Good night. Night, everybody.
Good night.
Greg.
Night.